10 minutes after 7 is our time as we get ready to settle down inside our number 2 of the Breakfast Roundtable for today, Monday, May the 22nd, 2017. And yes, we're going to continue to put the spotlight on some of the big headlines that are trending and that continue to trend, looking at the situation with the property tax and all the legal challenges. I tell you, it's like a soap opera that we see unfolding before us. We've got on the line with us Attorney at Law and member of the Police Service Commission, Mr. Martin George. Good morning, Martin George.
Hi, good morning to you, gentlemen. Good morning to your panel. Good morning, Dr. Wayne. Good morning, Edison. And good morning, Trinidad and Tobago.
Martin George, we see the legal challenges that have been put to the property tax. Government has been stopped dead in its track by that judgment delivered by Justice Franca C. Prasad on the issue. What are the next steps as far as you understand it? What should be done next? We hear that there may be an appeal being lodged or filed or heard or something like that today. Is this going to be a lengthy process? Will the courts expedite matters? What can we expect?
Okay, well, the thing is, from what I have been made to understand, based on the preliminary submissions that were made, the judge granted an injunction, basically suspending the government's implementation of the tax until the matter is heard and determined in full. Now, the thing is, from what we see reported in the media, it appears that the government may have filed an appeal or may have given an undertaking to file an appeal this morning, which is supposed to be heard. But the thing is, that appeal would simply be against the interim injunction. Now, the thing is, that has nothing to do with the hearing of the substantive matter.
Yes.
Now, normally in such circumstances, depending on the nature of the case, you may opt to not challenge the injunction, but ask for an expedited hearing of the substantive matter, because it may be in such a scenario that if it is that you ask the Court of Appeal to lift the injunction, then basically you are saying that you want to go ahead and implement the tax while the matter is still being heard. Generally, courts tend to err on the side of caution if it is that you're talking about an irrevocable scenario, and they tend generally to say, well, look, let's wait and let this stay continue until the substantive matter is determined. But of course, I don't know what novel arguments the state may mount this morning in their challenge to the injunction. But we must understand that this is just an appeal against the injunction. The substantive matter has not yet been heard and determined.
Mr. George, I'm Mr. Ram Logan, who argued the appeal on behalf of Mr. David Maharaj.
Could you just speak up a bit?
Yes, Mr. Ram Logan, who was arguing the case for Mr. David Maharaj. He is screaming bloody murder, and I think along with the Prime Minister, and they're calling collusion, because he is saying that the case was the injunction was granted on Friday. The government said that they will appeal. He spoke to the registrar and asked if any appeal was filed, and she said no. Lo and behold, on Saturday, he gets an email from the registrar saying that indeed what happened before, what did not happen, will happen on Monday at 9, that there will be an appeal. There was some talk of what the panel would be. And then again, it kept changing hour by hour over the weekend. So he's wondering if there's some kind of collusion, if the Attorney General and other people have a special line to whoever decides what will be on the docket for, let's say, a particular day. And the appeal is being heard today, so he doesn't know if in fact they will show up or what will happen.
Well, the thing is, I would say that, it's not at all a time one can impute without more any improper motives at all in relation to the judiciary. Because sometimes in emergency hearings, you are able to make contact and ask for things to be expedited. So it is possible that that can be done, and sometimes I guess the communication could get blurred along the way, because it's possible sometimes you may have an injunction hearing at a judge's home. It doesn't have to be in the courthouse. If it's so urgent, you may actually go home by the judge and the injunction to be heard there, because if you remember, the court is wherever the judge is. That's what is constituted as a court. So the thing is, it may be that maybe they gave the undertaking to file, and in anticipation of their undertaking, the court has, decided, well, look, we are going to try to fix a hearing. Now, the point is, I can't see realistically if it is that the applicant says, well, look, I am not prepared to deal with the appeal at this short notice. I need time to prepare. I don't know what your grounds of appeal are. I don't know what your arguments are. I don't know what your skeletal submissions are. Then in such a case, even though you may have, gotten the machinery of the court, in place to, expedite a hearing, the hearing itself may not take place today because the other side would be entitled to procedural fairness and you would be entitled to an opportunity to prepare yourself to argue the matter. So, notwithstanding the urgency, and I think it may be sometimes in cases like these a bit of, maybe ego coming into play to say, well, oh, you think you can stop me, so I will show you can't stop me. Sometimes these things do happen, unfortunately, with our high officials, but I can't see any court reasonably constituted, forcing one side to proceed in such rushed circumstances.
Whose duty is it then to alert all sides that there will be a hearing on a particular day and a particular time? Is it the registrar? Whose duty is it?
Well, the thing is, the courts would normally issue notices in the normal scheme of things. However, when you have expedited circumstances such as this, the other side obviously has the duty to notify the parties that, look, hey, I have filed an appeal and I am asking for an expedited hearing. Excuse me, the hearing date is scheduled for such and such date and time in this courtroom. So obviously there is a duty on the parties who have agitated the court to make sure that proper notification is given to the other side. Because
not the registrar?
The registrar may, out of courtesy in such a circumstance, issue notification, but the primary duty in an expedited circumstance such as this would be on the party who is seeking the expedited hearing.
Mr. George, good morning.
Hi, morning. How are you, Dr. Wayne?
Very good, sir. Always a privilege and a pleasure to listen to you and get your explanation. Now, I'm just thinking ahead, and for the sake of our listeners who might be, thinking as I'm thinking, if the verdict, if the learned judge Supersad, if he's the one, first of all, will be hearing the matter, correct? Because I heard something.
Matter, yeah.
Because I heard something branded about, I think by the AG, and someone was saying some other judge will be appointed, someone recuse himself, and so on. In the mix of the confusion there, I think I might have missed something.
Well, unless there is some either conflict of interest or you can show prejudice or some element of bias, then there's no reason for the judge to recuse himself. And the threshold and standard to establish prejudice or actual bias is very high. If you remember the case of Wellington Virgil versus Basdio Pandey, right, which went to the Court of Appeal, where Mr. Pandey made claims of saying that the magistrate was biased against him. The Court of Appeal set out, they went through the line of cases from the authority, from Goff and all those others coming down to show that you must establish a very real possibility of actual bias for you to be able to succeed in such a claim, because otherwise anybody could just make any frivolous claim and then you'd be having every judge recuse themselves. If you recall also in the EMA matter where they had a matter with the highway reroute movement, and I think the attorneys for the highway reroute movement had asked Justice James Abood, to recuse himself because there was a judgment in a matter that was tangentially impacting on the case that was before the court, and that matter had been brought by Gregory Abood, who is the brother of Justice James Abood, and he is head of the Fishermen's and Friends of the Sea. So they felt that, look, by that relationship, there ought to have been some basis for the judge to recuse himself. And the judge went through all the law and the cases and showed that, look, this has nothing to do with the matter before me, and there's absolutely no basis in law that you can show me for me to recuse myself. And he rejected their application. You know, so the thing is, the standard is very high that you must show very good grounds for asking a judge to recuse himself or herself from a matter.
So I'm fast forwarding because I want to go to verdict now. If this this decision is upheld, that it is proven that the government here in implementing the property tax is illegal, or there's some violation.
Let me just cut you. There's been no decision on that whatsoever. There's been no decision on that. What the court ruled is that, look, because of the likelihood of prejudice, and that's what always would be a guiding factor in granting an injunction.
Mm-hmm.
The risk, you weigh the balance of convenience. In other words, the risk of stopping it until the matter is determined,
Yes.
as opposed to the risk of allowing the government to implement it, and then later on it may turn out that the tax is, wrongly applied, it's illegal, it's unconstitutional. Then in such a case, a court will weigh that, and if the balance favors the grant of the injunction, the court will grant the injunction.
Uh-huh. Okay. So
This started from the cases of American Cyanamid and that whole line of authorities coming down, and we have lots of local cases where, you deal with the basis on which you grant an injunction or refuse the grant of an injunction.
You see, the piece of the puzzle here I'm trying to get cleared up, where I heard, if I heard it correctly, the opposition leader, Ms. Kamler, said she's willing to go all the way to the Privy Council with this?
Right. Now, that would be, I assume, on the substantive matter
Yes.
more so
Yes.
that she would have been speaking.
So walk us through the steps. Walk us through the steps to get to the Privy Council.
What we have
Yes.
here, the substantive matter has been filed.
Yes.
Attached to that was an application for an injunction seeking a stay of the implementation of the tax by the state pending the hearing and determination of the substantive matter.
Right.
The substantive matter has not been heard or determined at all. The state, from what we understand, intends to appeal the grant of the injunction.
Yes.
So in other words, the state is saying, look, even though the substantive matter has not yet been determined, we think you ought not to grant an injunction. Now, as I said, normally a court will weigh the balance of convenience. Look, is it fair to allow the state to go ahead and impose the tax in the face of the risk that it may possibly be later determined that it was illegal or unconstitutional? Or is it wiser to simply ask the state to hold your hand, let us determine this issue, and then whichever way the court rules, you will know whether you can proceed with your implementation or not. Now, common sense to a lay person would normally dictate that the course of prudence may be to wait until the matter is determined before seeking to implement it. But we would have to wait and hear what the government's arguments are as to why they are seeking to urge the Court of Appeal that it must not allow this stay to continue. So it would be very interesting to see what arguments they mount in that regard, because one would think, as I say, just from a layperson's perspective, that common sense would say, look, let's wait and have the matter determined before you seek to actually implement it.
Backpedaling a bit, Mr. George, Justice C. Prasad will not be involved, will not be the judge involved in this appeal, because I'm seeing here the Justices of Appeal, Peter Jambadar, Gregory Smith, and Judith Jones. They will be.
Justice C. Prasad is not a judge of appeal. He's a puny judge.
So who will?
He's not in the Court of Appeal.
But Mr. Justice C. Prasad, the one who granted initially the injunction,
Right. So
he
in
will
other
not
words,
be involved in the appeal.
It's his decision, but he has no role to play in the appeal.
But this is what I was trying to clear up. So
Yeah.
the Court of Appeal will.
It will be the judges of the Court of Appeal.
All right. So Peter
I'm-
Jambadar, Gregory
Let me
Smith.
just clarify the expression. The judges of the High Court are referred to as puny judges, but it's not the normal spelling. It's P-U-S-I-N-E.
Yes. All right. I'm just scanning through the judgment here by Justice C. Prasad. I think in paragraph 26, he talks about the court cannot say that the arguments that were presented to it were devoid of merit, or that the applicant's view on the issue is devoid of merit, and that is one of the reasons why the I guess the injunction or what have you to put things on hold was given.
That's one of the first things you need to establish in terms of an injunction. You must show that there's a reasonable prospect of success in your application, that you do have a good and sufficient cause, in the first place. So that's one of the things that you must establish ab initio. So the court obviously felt satisfied that there was some basis for such an application for the injunction, and obviously it's on that basis that the judge granted it.
So the steps would be now Court of Appeal, Supreme Court, and possibly Privy Council, Mr. George?
No, well, the Court of Appeal, and then after that, our next higher court is the Privy Council.
Oh, I see.
All right. Another interesting paragraph here in this judgment, paragraph 35. In democratic societies, there should always exist a circumstance where the law creates a climate of certainty. Citizens have a right to understand why they are mandated to act in a certain way, and more importantly, to be properly informed as to the sanctions to be imposed upon them if they fail to comply with the law. The public interest can never be served by the sanctioning of any process which imposes an obligation to act if that process is not premised upon a foundation that is lawful and constitutional. So again, a statement there indicating and seeming to agree with the applicant, that would have been Mr. Mirage, that there was a certain degree of unconstitutionality in government's attempt to get citizens to comply with the Property Tax Act. Yes?
Yes, I think that's what the judge found as a fundamental, basis for granting the injunction.
Some arguments flying about, Mr. George, is that this notice, is it a legal document or is it just a notice? Because there is some argument that, what was sent out to the public, as the case might be, was just a notice telling them what, so on and so on and so on and so on. And other people are saying, no, it is a legal document.
Which, you're referring to which notice in particular?
So the notice that was sent to everybody about, what you have to do to
that we've been getting in our mailboxes.
In the mailboxes.
Could that be described as a legal document?
Well, the point is, it would be an official document, but to describe it as a legal document as to whether it is a legislative instrument, no, it's not. It may be made pursuant to legislation, but it's not in and of itself a legislative instrument.
All right. Martin George, this is a pretty complicated issue, and we're going to wait to see what happens in the courts today. Thanks for squeezing us in. I know that you're really busy this morning, and that you're on the move.
It's always a pleasure.
All right, and thank you. Thank you so much.
Okay.
Thank you.
That's a senior attorney at law and member of the Police Service Commission, Martin George, speaking with us on the Breakfast Roundtable on Sky. We're going to continue to look at this issue, though, but from another angle. Martin George helped us look at it in terms of the legal issues. We're going to look at it in terms of, the possible economic impact and what it can mean for state coffers, depending on what happens and what the courts decide.
Sky 99.5 FM. Streaming live on Sky995FM.com.